Get ready, start. The challenge by the appellant is threefold. Full stop. Firstly, it is contended that prior to the respondent bank acquiring the said property in an auction sale, the same had been re-entered by the Land and Development Office of the Government of India, wing the leisure of the land underneath the property, and thus no title was acquired by the respondent bank, and the said property was not public premises within the meaning of section 2nd E of the PP Act, for the state officer of the respondent bank to pass an order with respect thereto. Full stop. Secondly, it is contended that no bona fide requirement on which ground the appellant was sought to be evicted had been established, and rather it stood admitted that the eviction of the appellant was with profit motive. Full stop. Lastly, it is contended that no proper opportunity to lead evidence was given to the appellant by the state officer of the respondent bank. Full stop. As far as the first of the challenge aforesaid is concerned, the admitted position is that when the respondent bank, after bidding for the said property in an auction, had applied to the court for confirmation of the sale in its favor, the L and DO had objected on the ground that the property having already been re-entered, no title could be conveyed to the respondent bank para. The said application of the L and DO was rejected, giving liberty to the L and DO to seek its remedies. Full stop. Not only so, the Supreme Court in Shanti Sharma versus Ved Prabha 193 has held that re-entry effected by the L and DO of lease with respect to the land underneath the property does not prevent the lessee of the said land from seeking eviction of his and her its tenant in the property constructed on the said land as owner thereof. Full stop. It was held that unless the L and DO pursuant to the said re-entry reposes the property, the lessee of the land is fully entitled to deal with the tenants inducted in the property constructed over the said land as owner, landlord, and the tenants of the lessee cannot challenge the title of their landlord. Full stop. Upon the senior counsel for the appellant being confronted with the said judgment, he had no reply thereto now. Full stop. Therefore, it has to go by the earlier decision of the court, which has decided that matter justifiably as such. stop.